Good morning, all my lovelies. How are y'all? How are y'all? Good morning. It's a big day, but we have made it to Friday. Congratulations. Ahoy! Casey is back. Oh my gosh, look at that. I got you earlier and I got you late. Look at this. I think this is how we capture our international audience. I got to fix this before Nash comes in. She's going to kill me. Whatever. We're going to fix our background and stuff this weekend, okay? It's all working. It's all a working thing. Let me move my ring light. Hey, guys, how is everybody? Are y'all gonna watch the debate live, or are y'all gonna catch it later? That ring light will work. Whatever. We'll leave it. We'll let some people come in here. So, oh, there's my Bradenton, Florida, Keith. He claimed it. You will forever be number one. Where's that close to, Keith? Swaney. We're from Arkansas. Yeah, right. Yeah, good. I'm glad you stayed up. I'm not going to keep you forever. So whenever I was going through these briefs, as I was telling y'all last night, southern part of Tampa. Okay, so it's hot down there right now too. I'm in an undisclosed location in the South, and I'm going to tell you, I love the heat, but you've probably gotten this too recently, and whoever else is in Arkansas. Well, I just gave that away. Yeah, I split my time between places, but originally you're from Centerton. Okay, I'm from Northwest Arkansas, so I split my time between here and California. Very cool to have another Razorback in the house. An SEC representing, right, Keith? Hi, Josiah, NWA. Oh, yeah, okay. Swaney can tell you it's also been literally yesterday, Keith. It was 111 degrees on the heat index, which is a no-brainer. But when you stepped outside, it was like you were in a blow dryer. We only have a couple of those days a year, and I was like, the breeze is not helping. Oh, nice. Okay, so I graduated from Southside, Swaney. I gave it away. I know. Yeah. Anybody else suffering through this? Listen, I have a theory though. I think because it's such high humidity here, it guards against wrinkles. But what do I know? Oh yeah, Florida is horrible. Hey, Lemon Curd. Hey, did you send me whatever you said we were talking about? My brain is all over the place. Class of 83. Okay. Okay. I'm not class of 83, but my parents are pretty close. They graduated from here too. Lemon Curd, I know we were talking about something. South Carolina sweltering. Yeah, y'all, it is crazy right now. Listen, in the South, we're used to this, but like these are the dog days of summer. It is so hot. And it used to be, I swear, like 30 years ago, I don't know, whenever I was growing up, it seemed like there was always a thunderstorm at like 2 p.m. to break it up. And it never thunderstorms anymore like it used to. That's pretty crazy. Yeah, San Antonio is crazy. It's like the Gulf, I think, has it the worst. So I've spent some time in Biloxi, and anytime I go back down there, it's like I have very straight hair, but whenever I go down there, it is like I can't even wash it. It's hard to describe. It's like just maybe the water is soft too, but it just gets to be so matted. Yeah. Well, it's not bad to sweat it out. Honestly, I still prefer this over freezing to death. I don't know about y'all. I don't do well in the cold. Okay, so this morning I've been going through those two preliminary briefs, right? And I wanted to pitch it to you guys in a way that you could understand what's going on. And the more and more I looked at it, I was like, oh my gosh, this thing is so massive. So as to not lose you guys, I'm breaking it up into 2 days. And I'm doing like this introduction, and then we're going to cover a couple of the charges that they brought against him. But then like tomorrow or Sunday, I'm going to do the heavy bulk of it, which they talked about. It's people have been asking me about the KGRB or whatever. It's no known great bodily risk, and why they spent so much time on it. And it's crazy because instead of you can't remember either. Okay, well, eventually we'll remember. We need to write it down, or it's in the messages. Okay, so back on track. Okay. I was surprised whenever I really started reading it. So they charged him with 7 different like counts of, of crimes. Okay. But obviously we know that the main one that carries the weight is murder. But it's interesting because in Utah, they can charge you with murder, right? But the sentence is 15 years to life. However, if they charge you with aggravated murder, that is like potentially the death penalty. And the only difference between the two, and this is the craziest law I've ever heard, is that if you put someone other than yourself and whoever you killed in danger, in bodily danger. So it doesn't even matter if somebody else dies or not. So what they did here, instead of just charging him with murder, which would be justice for Charlie, right, is they charged him with aggravated murder by claiming that he was putting everybody else in the crowd in danger. I was like, oh my goodness, I can't believe that slipped me, but really I think it slipped a lot of people. To me, that seems incredibly greedy just to put him up against the death penalty, because Charlie's the one who died. There wasn't anybody else who died. So why should, is the death penalty, like, who is that really serving? If really he could have just been charged with murder, because okay, remember, we don't think Tyler did it, but I'm just saying, like, we have to go off of what the prosecution is saying for a preliminary hearing. So don't think at all that I or the defense are conceding that he did anything. But we know somebody killed Charlie, whoever's responsible for it, right? But how is taking that up to aggravated when nobody else died really justice? Do you guys understand kind of what I'm saying? What are your thoughts on that? It's very extra. It's like nobody else died, but you are potentially like giving him the death penalty. I understand putting other people in like harm's way, but so many times in law, something actually has to come out of it. Does that make sense? Like, there has to be an end result. I can understand aggravated assault, aggravated battery, all that kind of stuff. That makes sense to me. But aggravated murder is like, I don't know. I think it may be tantamount to what we call felony murder in a lot of places, which is if you are in the act of committing a felony, let's say you rob a bank and someone dies as a result of that. And sometimes it can be as simple as like you give some of the most interesting cases were when somebody robbed a bank and somebody died of a heart attack. And that can be considered felony murder. So maybe that's what they're getting at here. But the only person who really was the victim was Charlie. So let me see what y'all are talking about here. Good morning, Mr. Feelgood. Welcome in. Wonderful ray of sunshine. I try to be a wonderful ray of sunshine for y'all in the morning. Asked if anyone's looked into children and families being present at any of the debates Wednesday. school day while our children and family there. I think that the kids were there because honestly, I mean, if Charlie Kirk was coming to speak around me, I'd pull my kids out of a class and take them. I'm going with first degree printed. It's kind of wild that yeah. I know, Crunk, you were. I know. I was going, what I was saying was when I not started, I mean, I've been going through this for a minute, but I was like, okay, with everything going on today and this stuff being very much, I'm going to try to not read it to you guys, but I want to show you how the defense has really put up a good defense here. So there's a lot of pulling from the documents and it's very wordy and there's a lot to go over. So what I've decided to do is break it into two. So we're actually going to save the aggravated murder and two of the other crimes that they've charged him with for another day because they all kind of relate. And so we're going to like jump into this, really go over what like a preliminary hearing is to kind of put everybody at ease because the consensus is, and it's nobody's fault. I mean, I'm a civil lawyer. I'm a civil litigator. So just because I've gone to law school and stuff like, and I've helped with some things, like I do know that a preliminary hearing is totally different. But I think most people, it's fair to say most people don't know how a preliminary hearing is different than a trial. And I think a lot of people were very concerned and upset by what the defense didn't do, which is why we need to go over the purpose of a preliminary hearing, the limitations, and you'll feel a lot better, I think. Keep your live video posted. So okay, hang on. If you put your chat on screen, you can keep your live to video posted. You can see the questions, comments, but you're replying to us. Okay, how do I do that? Does anybody know? Let's see. If anybody can tell me how to do that, I'll do it. I'll wait, see if anybody knows. I'm going to go through just some of these comments. If y'all are catching this on the replay, I have done a debrief of the briefs, and I'm going to go through and explain what's in them and kind of I've spun it in a way to where it's digestible because reading that stuff just like without any context and knowing even how to read something like this is like overwhelming and also very boring. So I think the way I've done it here is going to be good. I've broken it into 2 different days just because one of them is so there's a lot of information there. And that will help people understand why the defense took so much time on the known danger to other people. I think they do want to kill him too. I do. Well, I've gone back and forth on it. Like, I think they either want to kill him so that he can't speak, right? Because they could have just charged him with effing murder, and that would have, justified, brought justice to Charlie or whomever, if they've really done it. But for them to go with aggravated in a situation like this, and that's also, you're risking it because you're throwing it way high. Like, if you fall short of that, he's not going to be successfully prosecuted. Does that make sense? Like, we're operating from this standpoint, we're operating as if he is guilty, because they say he's guilty. They brought this case. So if they're saying that, they really need to prove it, and they're not. Stop saying Tyler would put you in harm's way. Okay. Evidence they say they had. Yeah, too. I am using StreamYard, Crunk. Are you going to tell me how to put my chats up? Do it with alternative. I don't know if it would be really appropriate for kids. I wonder if other events actually had kids there. Well, okay, I'll say this. Maybe not for Charlie Kirk, but if there was somebody, in the general sense, if there was somebody that my kids really, really liked and I allowed them to listen to him at home on their computers and stuff like that and they wanted to go see him, then I probably would pull my kids out. But it is interesting, Lemon, that you bring that up, because that's why how they are trying to get these other charges to stick. Open Studio, look at the comments tab. Okay. Right side panel. Okay. Find the message you want to display and click on it to make it pop up live in your broadcast. Okay, according to Google. Okay. I don't see it. Hold on. Y'all just hang out for just a second. I'm trying to see if I can just put the comments up. You know what? I wonder if it's not letting me. I think I can star it. Let's see. Let me do a star. I can put you in timeout. I'm not going to do that. Can y'all see that? No, it's not. I wonder if it's because I'm not monetized yet. I wonder if that's why the option isn't there. Let's try banners. No. Let's not just be clicking around. I know I'm getting pretty testy over here. Private chat recording. Rolling. Show comments on stage. Oh my gosh, you guys, if it was a snake, it would have bitten me. There we go. Can y'all see that? Y'all should be able to see it, because I'm just kind of talking to y'all. I'm proud of me. It was literally right in front of me. I'm not going to lie. Okay, let's do it big. Let's make it big. Ooh. Medium so y'all can see it. Let me see if whenever I scroll, it scrolls. Oh, it doesn't show that. Look at you guys. Y'all are awesome. I think it is an anomaly to yeah, it is very interesting to set him up for. So Lemon Curd makes a really good point, asking about like why were there kids there, because there weren't kids at other events. And that is very interesting because, as we'll see tomorrow, I'm going to talk about this tomorrow. Some of the aggravating factors are committing homicide in front of a kid less than 14. And yeah. So good. Okay. So are y'all going to watch the debate? Okay, cool. That's all right. Okay, I'm going to upload. We're doing it a little bit different today. We're going to, instead of slides, I'm actually going to do a PDF. I'm really proud of all of us. I'm not going to lie. It freaks me out with tech. Okay, so we're going to get into it. Okay. I'm sure I'll have comments that are like, get to it. But you know what? If they're not here for the live, they're just going to have to scroll for a minute. Yes, Janine. All the way, girl. I wouldn't have said that a year ago, but eyes are open now. Okay, so let's get into this, okay? And I'm sorry that there is a lot of text on your screen today. Can you guys see that? Is it, you know what? If it's too hard to read, don't worry about it, because I'm going to go through it with you. Cool. I'm going to go through it with you. Gaz, I mean, who Gaza? Either way, Gaz or Gaza, that's funny. Okay. So let's start out with what a preliminary hearing is. And I know that we've been over this for a while, but sometimes we need to go back over the basics. I know the green is a rough color. I realize that on screen now. So you're just going to have to listen to me instead of reading it. And I don't think you can read and listen at the same time. I realize that the green is very jarring. And the reason I did it in green, I was just trying to do it in another color, is I was trying to differentiate between what the defense and the prosecution said. So to keep track of that, I should have done it in another color, but doesn't matter. Don't listen, don't read it. Okay. I'll read it to you. So, all right, let's go back to it. What's a preliminary hearing? We are now like a whole month out of the preliminary hearing, but I think that knowing the bounds and like what the purpose is, I think that will really settle a lot of people's concerns about what the defense didn't do. Okay. Because when you understand what they can't do and like what the judge's role is and all he can do at this preliminary hearing and the whole purpose of it, I think you'll understand that it just isn't the time procedurally for the defense to bring up their evidence. Okay. So it's like the prosecution basically has to open the door and the defense gets what they get, right? And that's really all that they can combat at this stage. And I kind of analogized. Is it analogized? Y'all ever have like a word that you've said before a million times and you just can't get it? It's analogous to, okay, in civil court, and I said this like last night, in civil court, when you sue someone or someone sues you, there's a complaint. So think about the state filing charges against Tyler as the complaint. The defendant in civil court has two options. Either you can answer it, and that doesn't mean you're admitting it, right? Or you can do what we call in California, which is a demur, which is basically failure to state a cause of action. And that just says, like, good try, but you guys didn't like properly like cite the right elements, or you didn't plead it properly. But essentially, they're just saying you didn't meet your burden. Does that make sense? Like, and when you do that, when you do a demur, the court has to, and you have to consider that everything in the complaint, whether it's true or not, analyzed. I can't talk. The court and you and everybody has to consider that literally everything within the four corners of the complaint is what we're talking about is true, even if it's not. So you have to say, hey, even if all this is true, it still doesn't work because they failed to state a cause of action or they failed to like plead it properly. So that's kind of like what this is here, is the defense saying, okay, you guys have to show probable cause, but we have to also consider everything that you're saying as true, even if it's not. I know that sucks. I know it does. And the purpose of this, I mean, in history is, sometimes, I don't know, you get pulled over for a DUI and you don't want to plead guilty or whatever. You go to trial and you find out that the police officers didn't even write a report, it gets tossed out. So that's where we're at. And I'm reading Lemon Kirk, Tyler's lawyers, any of them from Utah. I can't say Massachusetts. I'm from the UK. Not from Utah, but Kathy Nestor is licensed in California and Utah. And the rest of the defense, they are coming in pro hoc from California. And they're some of the biggest, best trial lawyers there are. Really, I don't think you could have better. So they are skilled. And I think when we go through some of this, you're going to see why things weren't brought up, that we were like, why are you not saying this? And this will help. Okay. So the defense doesn't get the first call. Like, it's like the defense has to sit there and see what the prosecution's going to say, because it's the prosecution's burden to show the court, hey, we have enough reasonable cause, probable cause that this should go to a jury. And we call it the finder of fact. The jury is the finder of fact. So let's go ahead and go through this. I'm just going to read some things to you guys, and maybe this will help. And if you, at the end, you guys want a copy of it, I can send it to you. And it's going to change between now and like tomorrow for the next one that we do. Okay, so what is the purpose of a preliminary hearing and what are the limitations? So here it's, I pulled from a couple different sources and I combined from the prosecution and the defense. I didn't add in any of my own stuff. I did take out citations so that it wasn't so bulky, but together it comes together. So the purpose of a preliminary hearing, right, is not to determine the guilt or innocence of a person or of an accused. So that's what the prosecution starts out saying. You have to like lay out all the law, blah, blah, blah. So they go on to say, if the evidence supports probable cause to believe that the crime charged has been committed and the defendant has committed it, the magistrate, which is the judge, must order that the defendant be bound over for trial. So don't get like, also in each state, we call it different things, but binding for trial just means you got to go to trial. That's why the prosecution's brief said bind over for trial, and the defense brief just said, what did theirs say? Theirs said something else, but it's okay. No worries. My brain is okay. So it does not require proof beyond a reasonable doubt, right? That's what it requires to be convicted by a jury. They even go on to say it is even lower than preponderance of the evidence standard applied to civil cases. Thus, a probable cause showing does not require the prosecution to eliminate alternative inferences in favor of the defense. Let me stop and say. Oh, good. I'm glad that you could listen to me say all this stuff all day long. I'm glad. Keep tuned in. I'm not going to keep you all forever. And we're going to do this in segments so that it's, you'll be happy that we broke this up. So here, even the prosecution is starting out and saying, probable cause showing does not require us to eliminate alternative inferences in favor of the defense. So it's not like they have to even combat the defense on their inferences. It's just basically, hey, judge, this is what we think. Yeah, the defense thinks this, but I mean, we're saying this. I think that, and in that case, right, alternative inferences, that is a question for the jury. Okay, so yeah, grand jury's worse because sometimes, at least this is all public, So I think Kathy Nestor wrote this because it's pretty good. And I mean, I like her. I do. Okay, so they add in, right? This part is in green, and that's why I highlighted it. Sorry, it's so, like, I'm taken aback too. So they say a defendant may only be bound over for trial if the prosecution produces sufficient evidence to demonstrate probable cause that the charged crimes were committed and that the defendant committed them, right? So the threshold requirement is intended to ferret out, I love this, groundless and improvident, wow, look at me this morning, prosecutions, relieving the accused, so you're relieving like defendant from the substantial degradation and expense incurred to a modern criminal trial when the charges against him are unwarranted or even insufficient, right? So it is good. I know it sounds like, gosh, this sucks, but you don't want to go through a whole trial and then like find out that, I don't know, that the police report doesn't exist. That wouldn't be fair. So this is a good thing. Okay. So the defense adds in, as discussed further herein, the state's burden requires them to provide provide evidence to support a reasonable belief, and when the evidence considered under the totality of circumstances is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecutor's claim. So basically she's saying, they have to provide reasonable belief and in totality of the circumstances. I love that one too. That means common sense and like context. Like we don't just take these things, in isolated pieces. You have to consider them all together. And when that is wholly lacking and incapable of reasonable inference, like that's the judge. When the judge is not capable of even making a reasonable inference to prove something, like when he has to struggle, the court must decline bind over for trial. So the best part, I love it when the defense, like I love reading like replies and oppositions. Then she adds, the court is empowered to make reasonable inferences from the evidence, okay? But the court may not engage in speculation. And there was a lot where I felt like the prosecution was asking the judge to speculate a lot. I really do. So reasonable inferences are normal. Like what would a normal person think, right? Okay, so that is kind of the background of why we have preliminary hearings and the limitations on this didn't speak so much to what the defense can't do, but really the defense can't do anything except sit there and wait and see what they have. And even if they bring something up, it doesn't matter because that would go to the jury. Yeah. I'm gonna read what Lemon is saying. It's okay. You're good. This is a good place. He's just saying in the UK, their system works much differently. They have Crown prosecution. Police have to put the case evidence together to be good enough evidence that there's evidence the accused did actually commit the crime or the case doesn't go to court. Actually, that is exactly what this is. That's a really good way of putting it. That's entirely what this is. So it's on par. Yeah. Exactly. Okay, so this is actually what that is, Lemon. Okay, so we've got the Judge Graff there, right? So what is his role? He's called the court. He is called, we say the role of the court. He represents the court. And, we also can call him a magistrate too. So don't get too caught up in all the different like words and stuff. I think attorneys should just, the law should just like stick to one or something. But a judge is a magistrate. Okay. So the magistrate at a preliminary hearing, so this is the judge, must view all evidence in the light most favorable to the prosecution, right? So you have to give the favor to the prosecution. So it doesn't matter if the defense says something, right? Because if there's a question of fact, the jury is a fact finder. Right here, we're just saying, can you get over your hump to where we need to let the peers decide? And then, okay, so must view all evidence in light most favorable to the prosecution. Let me scroll down just a little bit. Hold on. And the magistrate has only a limited role in judging credibility of the evidence, right? So he can disregard or discount the prosecution's evidence only if it is so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element on that evidence. So, the standard is if it's just ridiculous. Like, okay, let's say we saw a black man in the videos. Like, they should say ridiculous. I like that word here. I think it should be a legal word. Okay. Otherwise, the judge may not accept the defendant's version of the facts over the legitimate inferences that can be drawn from the prosecution's evidence. So there you go. Bing, bang, boom. People are like, well, the defense has this. Yeah, that's right. We do. But if there are legitimate inferences that the prosecution, can present, then it doesn't matter. Like the judge has to go with it. Okay, so also that a magistrate may not prefer one piece of credible evidence of the prosecution over a conflicting piece of credible evidence in making a bind over decision. So basically, if both parties have a reasonable inference, it's going to be the prosecution. And the point is, it's not the judge who is determining the credibility, meaning what would a jury think? So I hope that gives you a little bit more of a background as to why this happened the way it did. And I think if people understood this, they would realize why this wasn't as horrible as it seemed. Okay. Read what you're saying. Oh, that's nice. So Lemon Curd says over in the UK, people aren't held in prison or jail. Has to be put to the Crown in order to put the charges on the accused, usually held in a police station, submitted within up to 72 hours, or the person gets released without a charge. That's cool. That would also not be cool if, I guess the alternative is I would want to get out on bail at least, while I waited. But I know some people aren't, they're not given bail. Okay. So what you see right here in front of you, this is a chart of the 7 different charges that were brought against Tyler. The ones that are shaded in blue are the ones that we're going to go over today. And it's just because number 1 and number 2, the aggravated murder and the discharge of a firearm causing serious bodily injury, those two kind of tie together with the greater known risk or known risk of great bodily injury, or however they say it, some acronym like that. Okay, it's early. And then number 7, we're going to do tomorrow too, because this is where, as Lemon was kind of talking about earlier, referencing a violent offense committed in the presence of a child. So they got him there. But there are also 2 aggravating circumstances there, which we will talk about later, that actually take the sentencing for 1 and 2 up. So don't worry about it. It's kind of complicated. That's why I'm not doing it today. So we're going to go over and just think of it as two different sets here. So count 3 and count 4 are both obstruction of justice. And they're both they have the same elements, right? For concealing or removing the firearm and for destroying, concealing, or removing clothing he wore during the shooting. Okay, so the first one is count 3 is for the rifle and count 4 is for the clothing. And then 5 and 6 kind of go together too. Tampering with a witness for either directing Twiggs to delete his text and telling him to refuse, to speak with law enforcement. That's how they titled it. So we're going to do those today and then save more of the heavy duty stuff for tomorrow. Because as you can see, it just gets very, I don't know, there were probably 80 pages to all this stuff. Okay. So I'm going to go through the facts with you guys as presented by the prosecution. And I highlighted here as I was going through them, kind of talking points for you guys, just because the way they spun them was a little bit different. And again, I did take out a lot of citations because it just gets messy. But most of the facts I'm okay with. And I left out the where they cited to the autopsy, which I think they should be sanctioned for because they were not supposed to release that at all to the public. And the fact that they, released a public document, even Kathy Nestor says in their brief that, they could have easily redacted this. Okay. So, all right, most of the facts I'm fine with, but essentially they're saying on that date, Charlie Kirk was holding an event at UVU with several thousand people near the center of campus and west of the Losi building. After the event began, he seated himself under a canopy tent positioned on the west side of the amphitheater, but below the Hall of Flags. Excuse me. I'm taking a drink real quick. That was a really loud slurp. Oh, I know. People are saying in the chat, obstruction, what about TPUSA? Oh, I know. I think that's going to be brought up during, that would be brought up in trial. The defense's hands are bound. That's a really good point. The defense has their hands bound in a preliminary hearing. They have to sit there and take it and see what they come up with. And if it's legitimate whatsoever or could be, it doesn't matter what they say because the judge doesn't get to decide. He just says, send it to trial. Okay. Yeah. Okay. So going through the rest of this, at approximately 12:23, an attendee standing directly in front of him, Charlie, was questioning him when a gunshot rang out and a bullet struck the left side of Mr. Kirk's neck, killing him. Okay, so here's the other thing. Even though a lot of us don't think that it was a bullet, you have to remember that they are saying it is. So for the purposes of the preliminary hearing, this is not the opportunity for us to say this is not how it happened. Chat slurp in all caps. Chat slurp, I know. You've been here. Too sleepy to wave. We're waving at you, Nana. And the only part of the autopsy that I even included here was that the bullet's trajectory was front, back, slightly left, and downward. I think it's crap that they put this in here. And I really hope that the judge reams them for it because they weren't allowed to say that at all. Because also, if it wasn't offered up as evidence for them to question, it's not fair for them to do this. Oh, Lemon Curd, I think that's what I wanted you to send me if you had it. Okay, so moving on. This is what the prosecution says about the investigation. When the bullet struck Mr. Kirk, Bagley was stationed on the south end of the walkway roof of the Hall of Flags above Charlie's canopy. Based on his experience with firearms, Bagley believed that the bullet came from a rifle fired from position east of Mr. Kirk's canopy. Yeah, I guess so, but they're kind of, and they drop down to this, but Bagley doesn't say that. He first says it was a handgun. That's what he says. And then he says later that he changed his mind, right? So I already don't like that. And then I have it highlighted here. Recognizing that the Losi building was east of the amphitheater and someone on the roof of that building would have a direct line of sight to where Charlie had been seated, Bagley quickly made his way to the roof. That's not exactly the testimony he gave, and that is, they did cite to that, but I pulled that out. I remember him saying that at first he thought it was like a handgun, and then he moves down to the amphitheater. And once things settle out and his adrenaline's not pumping, he's like, oh, that must have been a rifle. And he doesn't explain why he looked up to the Losi Center and decided it was there. That was like a problem I had. And here they're saying that he's realizing that someone on the roof of the building would have had direct line sight. Well, yeah, everywhere though. Like, why that one position? Anyways, facts are facts. That's what they're saying. But I think they're misstating testimony, honestly. Okay, there he observed a screwdriver about 10 to 15 feet from the guardrail. But remember, of course, that's whenever his his body cam went out too. Okay. He also observed disturbances in the gravel at the southwest edge of the roof consistent with a sniper pad, meaning a place where the person was laying in prone position with a line of sight to where Mr. Kirk had been seated. And I'm pretty sure he called it the sniper perch. Well, whatever. Cool. Okay, so Bagley reviewed surveillance video of the Losey's building rooftop, which, yeah, I mean, you should have, because we saw your earlier body cam footage and it caught the guy. So why weren't you looking up there? Or why hadn't you seen it before? I think I know why you suddenly decided it was from that exact area on the Losey building. So that video shows a male running towards the southwest edge of the roof. The reason I have that highlighted is because that was never in testimony. And I know it sounds like I'm being very particular, but nobody testified to it being male. They just all testified to who they thought it was, Tyler Robinson. And also, how rude if it was Lance and he's in transition to be a woman. I'm just saying, kind of rude. I don't know. I don't like them sticking things in here, though, that like were not on here. And I've thought about this too. How do they know that it was a man? I mean, I can take a look at it and say, hey, that's a man. But, if they had said that in the hearing, they'd be like, well, how do you know? But they go ahead and they just stick it in here. They said nothing about why they thought it was a man. Okay, so he's running towards the southwest edge of the roof, drops down, crawls, getting into a prone position at the edge of the roof. The video further shows that at about the time of the gunshot, right? We have to believe that it's a gunshot. The guy stood up, ran across the roof carrying a long, skinny black object, and eventually dropped down. I have black highlighted because I don't remember that they testified to that, but I'm just critically thinking here. How do they know it's black? Like, you can't say it is black. You can say believed to be black or observed what he believed to be black. But what if it was brown? What if it was dark red and it looks black on a camera? These are just, I know that it's nitpicky, but this man's life is on the line. Yeah. All the jobs. 30 seconds on the shot is insane. It's stupid is what it is. It's the most ridiculous thing I've ever heard. Okay, so that individual crossed Campus Drive and entered a wooded area on the north side of Campus Drive. They're saying it like that's a fact, and I have tried to listen to this over and over. It seems like to me they don't actually have footage of him entering the woods. They just say that he heads towards that area. Yeah, I would say this was a professional. This was a sniper. This is not him. Okay, in that wooded area, police later recovered a rifle wrapped in a black towel. It was an operable Mauser Model 98, blah, blah, blah. A telescope sight was mounted on the rifle. Cute that they actually use the whole word telescope. Hey, Crunk. Okay, thanks for stopping by. Have a great day. Hey, Trash, welcome in. Okay, so investigators reviewed hours of surveillance video to go back and forth. The person seen on the Losey building roof at the time. After defendant turned himself in, so conveniently, investigators also reviewed the footage searching for someone matching defendant's description and driving his car. Those efforts revealed that a vehicle registered to the defendant arrived on campus the morning of the shooting. I don't like that because they could have said a vehicle matching the description showed up on campus that morning. How do they know that a vehicle registered to Tyler is the one that showed up on campus? I didn't see. Okay, go run and get your groceries. I totally get it. But you see how they're like manipulating the facts? That is not what was said. I'm just highly irritated because language matters in something like this. And what is precise is that those efforts revealed what they believed to be a vehicle belonging to Tyler. But to say that the vehicle registered to him arrived on campus, they don't know that. They never had the license plate that morning. Yeah. Okay. Anyhow, moving on. Okay. The surveillance video also shows an individual believed to be defendant. How nice of them to finally use those words. Walking around the UVU campus that morning, going to the railing on the roof of the Losi building, and leaving campus. They ultimately determined that defendant visited the campus at least 4 times, twice before the shooting, a third time just before noon on the 10th. Wait, what? Hang on. Okay. This seems wrong to me. I thought it was twice before and twice after. I could be wrong. I'm getting stuff all mixed up. Anyways, I won't make y'all sit here and suffer through it. Okay, the surveillance video shows when defendant returned to campus just before noon. He was wearing different clothing, shoes were the same, walking with a limp. His roommate and romantic partner confirmed still images taken from that portion of the surveillance video and that show front views of the individual's face definitely did look like defendant. It doesn't, they have to use the facts they have, right? But they could have said, because it doesn't really show his face very well. It does show front views, but he also couldn't identify him from the other photos. Yeah, Ruth, awesome. I'm so glad you're here and that you're enjoying it for sure. If you didn't get the first part, skip ahead about like 20 minutes because that's about when we started. Okay, so given their extensive review of their surveillance footage, investigators concluded defendant was the individual who was walking with a limp upstairs, that accessed the Losi building shortly before noon, who was on the rooftop, and who dropped off the roof and made his way to the wooded area. Okay, it's like, all right, prosecution, if that's what you're saying. Mr. Feelgood, I'm glad you like it because it definitely took me some time to figure out how to present this to you guys so that it was digestible, but I think that this is the best way. Okay, so at approximately 12:36, right, that's whenever he's coming back to campus, and they say he was gonna try to turn into the intersection of Campus Drive, right? That's like that at the stoplight that we see. They say he attempted to turn right, it's the south, but was turned away by an officer stationed at the intersection. This is the first time I'm realizing that if that's true, the officer, said no because a shooting had been there that day, right? He's not going to let anybody come onto campus. Campus Drive leads to the wooded area where the rifle was found in the bushes. Well, that's a new fact. They didn't say that. Good. I'm glad. Was it in here? No, this wasn't in their facts, but the thing is they're saying he returned, that he was the one who was driving, and that was hearsay because Officer Goforth is the one who said that he interacted with that vehicle, right? And it was Hull who testified to that. But y'all remember too, Hull said that Goforth said, that's totally hearsay, that he believed that he had come into contact with Tyler Robinson. At that point, they didn't even have a name. And there were 4 people in the car, driven by a bald man. So please, do tell me. Like, okay, whatever. All right. So DNA testing of the screwdriver and the towel provided very strong support, which I'm not bothered by this. Let's see, very strong support for including defendant as having his DNA on it. They also talk about DNA testing from all over the gun and the cartridges, and that's fine because we expected that, right? So then the last little part here says that on the evening of September 11th, he surrendered himself to law enforcement in connection with the assassination, and that he also admitted to his boyfriend and other friends that he had shot Mr. Kirk. Okay, so those are basically like the facts with leaving other things out, and this is how the prosecution presented them at this brief, saying, "Judge, you should totally bind this over for trial." All right, so moving down, we've got a little bit of defense pushback. And this is where I think I'm attributing this to Kathy, but who knows? She's my fave. So she says, and this is also, just keep in mind, I pulled this stuff from 2 different briefs at one time. So this is not how it goes in order, but this is like a response to, one statement versus another. Or maybe it's not so obvious, but I know where to put it so that it flows. So she has said that as briefed and argued extensively prior to the preliminary hearing, and I will say, I looked at the docket and there was a lot of stuff like we didn't know what's going on. I'm telling you, they have been fighting for a year. It's impressive. The amount that they have fought over is crazy. So I will give the more benefit of the doubt to the defense now that I've seen all this. Okay. And as raised as a continuing objection throughout the preliminary, hearing, you remember her saying constantly that the state's extensive use of hearsay that was deemed reliable totally violates his constitutional rights. Like, it's hearsay. It's crazy. I think everybody was astounded. Like, what? How can this come in? All right. So she's saying the court may not bind over Mr. Robinson based upon the state's evidence consisting primarily of hearsay, which has not been assessed for reliability. And I totally agree with that. Let me check your comments down here. Crazy. Okay. So Gaz, how crazy would it have been for a cop on duty at UVU after Big Bang to maybe have been a little suspicious of Tyler asking questions? Yeah. I think any officer who was genuinely on duty would be very alert in reporting things. Like, if I were an officer and I was blocking off somebody turning onto campus at midnight, I would make note of it. But, he did the right thing. He said, well, no, actually, we don't know. We don't know exactly what he said. We just know that same car, allegedly, was found over at Miss Goforth's. And if y'all remember, Agent Hull had to be cross-examined by Nestor before he said, oh, yeah, it had 4 people. And it was driven by a bald guy? I'm getting a little bit messed up. But the point is, there were 4 people in that car. So also, why and how does Officer Goforth know that he came into contact with Tyler? Right? He grabs a partial license plate. Whatever. Honestly, not having a chance to slow and not pick that up. Yeah, no problem. Yeah, no problem. It definitely takes more than one attorney, I think, to help explain this. And I am someone who has to see things and hear about it in the most basic terms to really be able to grasp something. And it's hard sometimes when you don't get the concept. So sometimes I teach it from as if nobody knows anything. And because whenever people have done that for me, things click. So you're welcome. I'm really glad you're all in here. And let me just make sure we're doing good with time. Okay. I think that their debate starts in an hour, but we're going to be done. So, okay. So she's saying basically, hey, like, okay, but all this stuff has come in and there's hearsay and we haven't even tested it for reliability. Like all of it, like all the statements, none of it comes in. The only thing that is legitimate are the DNA samples, because it is what it is. And it's fine because like, duh, it's his gun. We expected that, right? But the text messages, those were pictures on a phone. Like, I feel like I can't, and I think everybody feels like this, but especially as a lawyer, I cannot believe that. Cannot believe they didn't confiscate his phone. And to me, that tells me that they're in on it, because no law enforcement, none of us would ever be able to get away with this. Just saying. I know I wouldn't. Let's see. Reading some more of your comments too. Mm-hmm. Yeah, Bagley, I can't figure out if he knew about. So I do know that they found, he said there was a holster, right? And he said there was no gun in it. However, there was also a holster with a gun found in it that day. So I can't jump to it and say that it's not the same. Like, they could be different, but how many guns go missing? I think we've talked about that. Oh yeah. No, they didn't seize Charlie's phone. Yeah, he said he found the holster, but later on they said, were y'all aware that a holster with a gun was found? So I don't know if that's the same holster. Do you know what I'm saying? It's not really clear to me, just like how many backpacks were found that day. I don't know. Okay. So moving on here. So she says, this is particularly true as it relates to evidence cited by the state to establish identity for all the charge counts. Like, y'all are using hearsay to identify him. The evidence consists largely of alleged communications between Robinson and Twiggs. It is alleged communications between Robinson and other individuals on Discord. True. How do we know it was him? We didn't even get to see the Discord messages. They didn't even show us that. And identification of Robinson from the surveillance footage, right? It's just all hearsay. Okay. So this evidence came from or became presumptively admissible through a recorded interview between the Utah County Attorney's Office and Lance Twiggs, a witness the court would not allow Mr. Robinson to seek subpoena from another state to testify at the preliminary hearing. Yeah, it's not even fair that like they didn't get to cross-examine them, but they were, he honestly, he should be sitting there as a co-defendant. Like, it really blows my mind. Yeah. Reading something. Yeah. Poorly written budget movie. I know. It's horrible. Like, I can't even believe that this is a state case. Okay. Okay. So that's kind of the background. And like I said, there's a lot of stuff. That's why I think today was a good day to just talk about the background. And then we're going to talk about counts 3, 4, 5, and 6. Okay. So 3 and 4, you can think of as grouped together. And this is obstruction of justice. And if we think about count 3, it's about the rifle, and then 4 is the clothing. So to meet that, the elements are defendant with intent to hinder, delay, prevent the investigation, apprehension, blah, 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 punishment of any person regarding conduct that constitute a criminal offense, destroyed, removed, concealed, an item or thing. So basically they're saying, like, he got rid of stuff because he knew that there was going to be some kind of investigation. So here they have defendant admitted to Mr. Twiggs. Now, this is the prosecution saying this. Defendant admitted to Mr. Twiggs he had concealed his rifle by leaving it in a bush and changed outfits. The surveillance video also shows him moving both towards and away from the wooded area north of campus where investigators found his rifle, which is funny because didn't they just say that they had video of him going to the wooded area? They're just kind of a little inconsistent. As for his clothing, consistent with defendant's admission to Twiggs, the surveillance footage showed defendant returning to campus just before the shooting wearing different clothing than he wore during his previous campus visits. And defendant also admitted to Mike Mitchell. Does anybody remember that? Does anybody remember that coming in? Because I sure as hell don't. Like, this part didn't. Why weren't we allowed to see this? Defendant also admitted to Mike Mitchell. That was the friend who helped Tyler turn himself in, the former Boy Scout leader. He admitted to Mike that he discarded the clothes that he wore during the incident. Okay, so scroll down just a little bit. So they go on to say all of this evidence establishes reasonable belief he had removed, concealed the rifle and the clothing, and therefore probable cause to support the counts, right? 3 and 4. And evidence also establishes probable cause that he intended to prevent a criminal investigation, and they cite to the text that he sent to Lance, hope to keep this a secret. If I were able to grab my rifle unseen, blah, blah, blah. Basically, they're just saying, like, they're using those text messages to show that he intended to get rid of it. And they talk about the note. And they say that these admissions demonstrate that he knew a criminal investigation for murder would follow. And he intended to obstruct the investigation. Okay, so they're saying that that's enough to get the charges. Now, the defense doesn't speak directly to this, but they did say that the bind over should not apply to any of the counts, right? So even though they didn't directly speak to this, they've already gone ahead and said, hey, like, this is all based on hearsay. This is exactly the hearsay. And also that, you need to throw all this out. So even though they don't speak directly to this, it's okay to me. So let me see what y'all are saying in here. Okay, so Lemon says, was Lance paid for his evidence? The rest of Tyler. FBI offered $100,000 if he was paid this reward. Is this evidence even allowed in court? It would be. Yeah, it would be. But see, this is why people were upset about the defense, is because I don't think they realize that defense doesn't get to do anything right here. They don't get to present like their own evidence. They can try, but it's really up to the prosecution. Like anything they present here that's counter, it doesn't matter because the court has to rule in favor of the prosecution at this point. But what they've done here is what they should have done and said, hey, this is all based on hearsay without assessing reliability. Yeah. Okay. I know. Rabid, right? So Rabid says, very odd that every bit of evidence they're presenting is tied to the person they immediately gave immunity to. I know. Twigs. Yeah. I don't know. I don't know how they can use hearsay. I don't know. There was some rule in there and about hearsay being like, I don't know, like hearsay didn't apply to a preliminary hearing. It sure as hell should. Which is weird because, they're examining the actual witnesses who are in there, which are all the three lab ladies. And I mean, they're going back and forth on that. And it's like they're sitting there able to testify to what they wrote. Okay. Like, I can't believe y'all are going round and round about that, but whatever. I thought the guy had been a cop. Yeah. So Mitchell was a former law enforcement, I think, with the city or the county. I don't know about getting rid of Tyler's clothes. I hadn't heard that, but he had told his family, don't touch my room. Yeah. Yeah, I agree with you. Okay, so those are counts 3 and 4. And that's kind of why I wanted to do those today, because they're a little bit easier to get to. As y'all can see, there's a lot of meat to this stuff. Okay, and then just 5 and 6, and then we'll be out of here today. But so 5 and 6 are grouped together, and something's in my nose. Okay, hang on just a second, y'all. Let me blow my nose. Hang on. Oh, Nana. So the Boy Scout leader is the same person as the former police officer, family friend. Okay. So counts 5 and 6 also kind of go together. So it's tampering with the witness. It's 2 different counts of it. So count 5 would be telling him to delete the text messages. And then number 6 is telling Lance not to speak to the authorities. So they have to establish defendant either believed that an official proceeding or investigation was pending, right? So we know that, or intended to prevent an official proceeding or investigation, and attempted to induce or otherwise cause another individual to withhold testimony, information, document, or an item. Okay, so the prosecution writes here, after defendant made several incriminating admissions during a text exchange with Mr. Twiggs, right? We know what that's about. Some are, which just are described above. He told Twiggs to delete this exchange and not to speak to police. So they're saying that, basically elements 1 and 3, it was defendant who attempted to have him withhold testimony. That's what they're saying. And they're saying that the second element here is that Tyler believed definitely that an investigation was pending. And as he explained in the note, he predicted by the time that Lance read this that he'd be dead or facing a lengthy prison sentence. And he also explained in the text that he hoped to keep the secret, blah, blah, blah. Let's see, scroll down just a little bit. They just talk about how clearly he knew that there was like a canine searching that was preventing him from retrieving his rifle. And it was after this that he directed Twiggs to delete their texts and not to speak to police. And that's what they're saying is establishes. Oh, I realize I'm not even down there. Okay, don't look at all the green, y'all. Just listen to me. Okay, so that's what they're saying establishes probable cause for 5 and 6. And then this is what the defense says back, but just listen, don't look at the green. So she basically says count 6 charges Tyler with tampering with a witness, but the information alleges he committed these offenses by directing Twiggs to stay silent if police question the roommate. And that's like not what happened here. She says the state alleges by telling Twiggs to exercise his right, I love this, under the Fifth Amendment to ask for counsel and remain silent, that, Tyler attempted to cause his roommate to withhold information. I love this part. So she says this must be stricken because his advice to Mr. Twiggs is consistent with the long-standing constitutional principle that every person has the right to remain silent. And there's case law for this, the allegedly improper statement, as the prosecution is saying, it demonstrates that it was purely altruistic for Lance's benefit rather than trying to obstruct an investigation, which I love the fact that there's case law on this. So the case law basically says that when the inducer's motives, that would be Lance, in advising Tyler to remain silent is to impede the investigation against him rather than give him purely altruistic advice, he is obstructing justice. And she says, therefore, the inverse is true. Where advice is purely altruistic, one is not obstructing justice. So his advice to Mr. Twiggs was, and I won't read all this stuff to you, but basically, if the police ask you questions, ask for a lawyer. My lawyer should be Doug Terry. I can see if he'll reach out to you. Make sure police follow the right procedures, proper warrants, but be polite. And she goes on to just say, basically, the rest of the texts are just altruistic advice, not saying, don't talk to them. And then, she lists off a couple of things that he says, like, I'm going to miss you. Please be good. Leave the room alone. Like, meaning don't touch it. The feds will search it top to bottom. Like, basically just saying don't mess with. Yeah, don't mess with the investigation. So there's some other statements in here we've all read. Well, some of them I never remembered hearing because they clearly left out some of this stuff. So she concludes by saying that, these are altruistic tasks for a lawyer, and it does not support the state's allegation that this statement by Robinson was made with an intent to prevent official proceeding, and that the count 6 must be stricken. I believe that is all we have today. And I'm glad that we cut it off here because there's just so much with counts 1 and 2 and 7 that it's a lot. It's a lot to take in. So that is today's presentation. I hope you all got something from it. Let me go back through and read some of your comments now. Okay. Okay, let's see. Do you understand why the defense did not want the autopsy information introduced? I didn't get their objection. I think it wasn't just the defense. I think it also was, it probably had to do with timing and the fact that they didn't have, this was not the opportunity to have their expert witness testify, right? So they probably saw that as prejudicial, but I will say too that she was saying that there are some things in there that should never be published or, known. So to me, I'm thinking that maybe something like with his, I think a lot of us think that something exploded under his shirt. So I have to wonder if it was like damage to his genitalia, something of that nature. But from a legal standpoint, when you're sitting in a preliminary hearing, you don't have your expert witness up there. And what they didn't want is a jury, if they're going to go to trial, they didn't want a jury hearing this information without the opportunity to get their witness there until trial. Like, they didn't want a preconceived notion because right, whatever is introduced the preliminary hearing, you just have to take it as fact. So it could be that they don't think that he was killed by a gun. That could be it too. There is always a reason. I know it's hard to sometimes understand. It's like, I don't get it. But after reading these, there were some questions that like Nestor was asking, and I really wasn't sure where she was going with it, but it's very evident. Let's see, the operation failed because someone was supposed to have murdered Tyler. Probably. Absolutely. Somebody probably chickened out. It was probably Lance. What do you bet? Okay. Let's see. Whole thing is playing where it was supposed to believe Tyler was a shooter. I can't test once. I know. You're welcome. You're welcome, Gauze. And yeah, thank you all for being here. I know this is like a lot of info, but I hope the background on what a preliminary hearing is, and like the defense's hands are just kind of tied. And I think that's probably why. That was a really good question about why they didn't want the autopsy released, is because, if we're not going to trial for a while, that's forever for a jury that's going to get impaneled. Impaneled means like picked, right? And everybody on the face of the planet has heard about this case. So if they weren't able to present, alternative testimony at this hearing, which they wouldn't, it would go beyond the scope of the preliminary, as they were saying a million times. They probably didn't want that out there. But I also have to think that it could be that they don't think that he was killed by a gun, or, they really want their witness up there. And if you put an autopsy out there, when you think about taking that to trial, that autopsy is going to be so scrutinized. You're going to have so many expert witnesses. I mean, that is like the bulk of it. You don't really want that coming out in the preliminary. Like, we know that he's dead, but I think too, maybe like the explosion in his genitalia. I mean, there's probably some stuff there. You're welcome. You are so welcome, guys. Yes, thank you all. Okay, so I'm going to release you guys. Go watch the debate. It's starting in 30 minutes, and well, you got a little bit more time. Yeah, and if you're in here and you haven't subscribed, definitely do, and click the like button before you go. And we are not monetized yet, so if you want to support financially, you can by finding the link, buy me a coffee, but you don't have to use it. I just appreciate you guys being here. We are definitely building this channel, and I love giving you guys a new spin on everything. So love y'all. We're going to probably do some stuff over the weekend, so make sure your notifications are turned on. But other than that, take a break. If you have to unplug this weekend, freaking unplug. This is too much for anybody. And enjoy life, okay? Yeah, you're welcome. Love you guys. Have a good day.